Today's topic is going to be frivolous claims of confidentiality or trade secrets. America has an epidemic of frivolous litigation, folks, and that epidemic has nothing to do with slip and falls, old ladies spilling hot coffee on their laps, medical malpractice cases. It's nothing in that arena. The real epidemic of frivolous litigation in America today is frivolous litigation, frivolous lawsuits involving bogus claims of confidentiality or trade secret protection. And you see this in two specific arenas. One, you see it in cases that go at trade secrets and claim it's a trade secret either under the Uniform Trade Secrets Act, which has been adopted by the vast majority of states in America, or under the Federal Defend Trade Secrets Act. You see it there. And then you also see it in the Noncompete context, where plaintiffs claim that the enforcement of the non-compete is necessary to protect an interest in confidential, proprietary, or trade secret information. And I'm telling you point blank that this has reached epic proportions. It's reached a critical level. It's becoming a crisis. Okay? Without further ado, I'm just going to jump right in. So, number one, why do companies do this? Okay? Years and years ago, when you think about competition in America, you think about capitalism and markets in the American economy, you know, what will come to mind, right? May the best person win, right? Ruthless, aggressive, fight tooth and nail for market share, open, fair, aggressive competition. That's always been synonymous with business in America. Unfortunately, over the past 15, 20 years, we've entered an environment where competition, ordinary competition, is regarded as somehow suspect, unfair, nefarious, right? All you have to do is attach an allegation about trade secrets to it or a non-compete agreement to it, and never mind the actual underlying merits of what's at issue, right? Never mind that the information is not really confidential. Never mind that the customers are available on Google and LinkedIn. Never mind that there's nothing remotely proprietary, unique, or extraordinary about the business's processes, methods, technology, etc. All of that goes by the wayside once the plaintiff screams trade secrets or non-compete. And that's a huge problem for America, because what it's doing is it's resulting in the suppression of ordinary and lawful competition. And although this will blow some people's mind, the mere existence of a non-compete agreement does not make the competition per se unlawful, right? Because the non-compete agreement could, by its own terms, be overly broad, overly restrictive, or in fact outright unenforceable for lack of any legitimate business interest. And if there's no legitimate business interest there, then it's an illegal restraint of trade and it completely goes away. So the reality is we have so many of these cases in which the plaintiff is using either a non-compete agreement or trade secrets to suppress ordinary lawful competition. And the consequences of that are disastrous. It's a raising rivals cost strategy, right? Non-compete and trade secret litigation has become the new weapon of corporate America, the new weapon of the well-capitalized marketplace rival to stifle any other nascent market entrants, any other threats to competition. If they perceive you as a threat to competition, they are probably going to sue you for something. And most likely, it's going to be for non-compete or trade secrets. You want to get even further afield, it's going to be for trademark infringement, patent infringement, whatever. But the real crisis is in the non-compete and trade secret arena, and it's often built upon frivolous claims of confidential information. So what does confidential information actually mean? What does a trade secret actually mean? And I know there are some jurisdictions, some courts, that distinguish between confidential information on one hand and trade secret information on the other hand. And I think that's a distinction without a difference, because look, it works like this, right? Let's take Florida non-compete law, where the plaintiff can demonstrate that they have a legitimate business interest in confidential information, and that protection of that confidential information is necessary to protect them against unfair competition. Let's unpack that, right? What does confidential information really mean? Well, if you distill the Florida case law makes it clear that in order for information, confidential information, to be of a type that constitutes a legitimate business interest in this context, it must meet the following factors, right? It has to be confidential, proprietary, and unique to the plaintiff, meaning it is not otherwise available to other competitors in the same market. If the information that is being claimed as confidential or trade secret is available to other competitors in the same market, then it is by definition not confidential, not proprietary. That's one. Two, it must be economically valuable. Three, if obtained or misappropriated, it must be of the type that a rival could use it to engage in unfair competition. So you have to go through this entire sort of logic chain where, okay, it's confidential, it's proprietary, it's valuable, it's not available to other rivals in the marketplace, and if obtained by them, they could use it to engage in unfair competition, and you can show how, right? Well, that's how courts define confidential information as a legitimate business interest in the non-compete context, and that sounds an awful lot like a trade secret, because even in the confidential information context, right? If you can demonstrate that it was not kept confidential, it was shared with many people, it was publicized on the internet, etc., then it's obviously not confidential. And so that ties into the trade secret context, what's known as sort of reasonable means to maintain the secrecy of the claimed trade secret. So regardless of whether we're in the arena of confidential information in the non-compete or NDA context versus confidential information in the trade secret context, is largely the same framework in terms of what constitutes confidential, proprietary, or trade secret. The same underlying rationale and the same underlying logic will apply. So the problem that we're seeing is in hundreds, if not thousands of cases, these corporate plaintiffs who for the most part are, as between the two litigants in the lawsuit, these corporate plaintiffs are the ones that are incredibly well capitalized. They're the bigger companies, whether they have hundreds of millions, if not billions of dollars, right? They're the big bully on the block, okay? These companies, these corporate side plaintiffs, they file trade secret lawsuits at an alarming rate. If they can get you on a non-compete agreement, they're going to sue you on a non-compete agreement. If they can't get you on a non-compete, they're going to sue you for theft of trade secrets. And invariably, we see the same types of allegations at issue, okay? And what do these allegations look like? Well, more often than not, the allegations are shockingly generic. They are raising things like our customers, our customer information, our processes, our methods, our standard operating procedures, right? Let's unpack some of these things, okay? Customers, right? In what context would one's customers truly constitute a trade secret in the year 2020? Well, I can think of a couple, situations in which the identities of one's customers might truly be secret, might truly be proprietary, right? So what if you are what if you're a landscaping business? And this is one of my favorite examples. You're a landscaping business, and you have a contract with certain sort of very high net worth individuals to do the landscaping and yard maintenance at their elaborate estates all throughout the country, right? You have a high-end landscaping business with a portfolio of high net worth clients throughout America, and fly all over, and you do their projects. Oh, okay, I could see how maybe that could constitute a trade secret if these people are sort of reclusive billionaires, right? And they're living off the map somewhere in Arizona or in the mountains or some elaborate estate that nobody can get into, right? Like who they are and knowing how to contact them, if you have their personal cell phone number, right? If you can call Bono on the phone, or Tom Cruise and say, hey, Tom, let me come over and do the yard. I just, left one company. I'm starting a competing business. Okay, I could see how that could possibly constitute a trade secret, right? Something like that, right? But outside of, sort of limited situations that sort of fit that kind of concept, I don't understand how customers, even if they are included in a list or a database, are going to rise to the level of being confidential, proprietary, protected. This is particularly so when we consider customers that are corporate, right? The notion that the identity or the contact information of a corporate customer being a trade secret is absolutely absurd. I've been in cases where I was in a case, not too long ago, where the plaintiff was alleging that the names of various grocery stores and gas stations were a trade secret. I was in a deposition, and the lawyer on the other side actually ended the deposition. He unilaterally terminated the deposition when I started asking questions about, for instance, hypothetical Walmart, right, or Publix, right, and claimed that I was getting into their trade secrets, right? I'm sorry, but the identity of a public corporate client is not proprietary. It's not confidential. It's not protectable, right? I've seen this. What's interesting is I've seen this in a particular industry context in several cases, maybe even a dozen cases at the point in time. I have seen this in this sort of broader healthcare space, right? And maybe one of the reasons for this is because the healthcare sector is, one, such a high dollar arena, right? There's so much money in healthcare, whether it's healthcare, pharmaceuticals, sort of the financial aspect of healthcare. I've seen this several, if not a dozen times, in litigation in the broader healthcare space, where corporate actors who are attempting to stifle competition argue that their clients are somehow a trade secret, that the identities of their clients are somehow a trade secret, or that knowing the right person to contact at a certain corporate client is a trade secret. Whether we're talking about pharmaceutical companies or hospitals or healthcare plans, the reality is that these types of allegations should be laughed out of court, point blank. But they're not. They're actually given absolute credence, and the corporate plaintiff is allowed to drag the other side through months, if not years of litigation, force them to rack up hundreds of thousands, if not millions of dollars in attorney's fees, litigating over the core issue of whether or not a hospital is a protectable client, whether or not their identity is confidential, whether or not the contact person at a pharmaceutical company or somebody who works in a hospital or a healthcare plan, whether or not these identities of the companies and the contact people are protectable and proprietary. I've seen this in several, if not dozens, of my own cases and matters. So that addresses the sort of customer piece of this, which we see frequently leveraged. It's one of the most common allegations in the trade secret context that, oh, no, we have customers. They have our customer information. The other piece of the sort of customer allegation that I consider highly problematic is the allegation that, the other side knows what our customers want, right? They know our customers' preferences, okay? Maybe sort of in the absolute, most aggregate, right? If there are, thousands of transactions and records and purchasing history, then maybe that could constitute a trade secret in an aggregate sense as a database, right? But just general knowledge of customer purchasing trends, I don't think that rises to the level of being confidential or a trade secret, because the customer is always shopping. Customers are always looking for more competitive offers, more competitive vendors, new products, new services, novel solutions, right? And if a customer wants XYZ, it is their right and their purview to tell you that they want XYZ. Customers frequently shop. They shop multiple vendors, especially for big ticket items where there's millions of dollars at issue. They shop, they get competitive pricing, bidding, proposals, etc., and they know what they're going to pay and they know what they want. So, in anything less than sort of the absolute most aggregate sense, right? A massive database, somebody lifts a sales force, right? Then maybe it's a trade secret. But otherwise, in the vast majority of these types of cases, I do not consider this type of information a trade secret, and it should not fairly be considered a trade secret. But the problem that we're seeing, not only on the customer information, we see it, we see the same problem when it comes to methods, processes, standard operating procedures, right? So many of these things are literally on Google, okay? You can look it up, right? You look up the company and the company is publicizing its methods, its processes, its procedures, right, for anybody to see. Or the company's standard operating procedures, which it portrays as a trade secret in litigation, those were really just lifted from standard industry guidance regarding whatever the best practices are in a particular industry, whether it's hospitals or hospital finance or pharma or whatever it is, right? Any industry, you can go online, you can find standard operating procedures. So what's the core of sort of what's going on right here in this situation? Well, a couple things, okay? One, at the core, there is a certain culture. There's a culture problem, right? And the culture problem definitely ties into non-compete agreements. There's a non-compete culture problem, right? Where courts have become, in certain jurisdictions, certain courts have become so used to enforcing non-compete agreements without truly scrutinizing the existence of a legitimate business interest. It has become a matter of routine, right? It's just standard practice to enforce non-compete agreements. There's almost a presumption that, it's a non-compete, it's enforceable. We do this all the time. In fact, I've been in cases where I've had courts and judges tell me, well, I enforce these all the time. And that was never how things were supposed to be, right? Like non-compete agreements were supposed to be intended to prevent unfair competition. And the threat of unfair competition was much higher in this context prior to the emergence of technology and resources such as the internet, Google, LinkedIn, all of these publicly available databases, right? Like if somebody starts a widget company in Idaho, and they just left a widget company in Idaho in the 1970s, then maybe them knowing about who their previous employer's customers were, maybe that's going to give them an unfair advantage back then, but it certainly doesn't in the year 2020 with all of the publicly available data and resources that are at anyone's disposal who has an internet connection. And so unfortunately, in this direction, courts have not kept pace with reality. Courts have not kept pace with the facts on the ground because we see far too many lawsuits and far too many decisions and rulings where the court almost hesitates to recognize the facts of this sort of new reality in the new competitive landscape, right? You cannot apply case law from the 1980s or 1990s or even 2000 or 2005. You cannot apply case law in the non-compete and trade secret context that addresses facts to the facts on the ground today, right? By that I mean whatever might have been confidential or proprietary or a trade secret in 1980 or 1990 or 2000 or 2005 or 2010, that might have been a trade secret back then. It might have been proprietary back then. It might have been unique and incredibly valuable back then. That doesn't mean it's the same thing today because of the pace at which technology has advanced, and particularly the pace at which access to information has advanced and has grown to the point where, if you have an internet connection, you can get on Google. I mean, you can basically run a competitive business if you have half a brain. So that's really the crux of what we're seeing in the non-compete and trade secret arena. We're seeing all sorts of frivolous cases. It's an epidemic. Plaintiffs are routinely, alleging these broad sort of categories of information. They're not even specific trade secrets. They're not specific identifiable trade secrets. They're just buckets of information, right? Customers, customer data, processes, methods, best practice, standard operating procedures, technology. Most people just everything in the kitchen sink, generic buckets. And it's only, if you have a good, sophisticated judge who is going to weed through this. And beyond that, you see many of these cases filed at the state court level. And in most state court systems throughout America, these state court judges, even state court judges who are outstanding jurists, they are overwhelmed in terms of the sheer volume of cases that they have to handle. Their dockets are absolutely massive. Most state judiciaries throughout the country have funding shortages, they have manpower shortages, they have a backlog of cases. It's virtually impossible for litigants to get a sort of fair, thorough process, where a court has, 1,000 or more cases that it has to move through the docket. So it's particularly acute at the state level, because at the federal level, there's you have a bit better odds at the federal level of getting a truly frivolous trade secret case dismissed on the front end with a motion to dismiss for failure to satisfy the applicable pleading standard, aka Twombly. But at the state court level, it's far more rare to see trade secret cases dismissed outright on the front end. In most state courts throughout America, at least from my experience and my perspective and from all I've seen and done and read, it strikes me that most state courts are fairly hesitant to dismiss a trade secret case. They're going to give the plaintiff the benefit of the doubt. So as a result of all this, one of the big externalities here is that you have companies, you have competitors, you have rivals, you have startups and nascent market entrants. You have competitors who have a viable alternative to these entrenched corporate actors. They have a new product or an alternate product or service. They have something that's novel, that's better, that's more efficient, and they are a threat to take market share. And what happens is, by jamming these, sort of defendants up in litigation, the company is getting a number of different benefits, right? The plaintiff company, right? The corporate plaintiff, they're getting a number of different benefits. One, they are costing the defendant, as we've established, they're costing the defendant hundreds of thousands, if not millions of dollars. Two, they're getting intrusive discovery into whatever the defendant's doing or creating on the business side, right? This sounds absurd, but this is absolutely one of the most standard corporate tactics in the current American competitive landscape. One of the most standard corporate tactics of today is you sue your rival for theft of trade secrets, and then you bury them in discovery, and you try to get the most intrusive discovery possible, where you seek every document, every email, every report, everything about their technology, their new products, their customers. So I've seen so many cases where the plaintiff who sues for theft of trade secrets is actually using the litigation in an effort to steal the defendant's trade secrets. That's where America has gotten to, with sort of this non-compete and trade secret absurdity over fake confidential information. So one is raising their costs, destroy them with legal fees. Two is subject them to intrusive discovery, where you can in addition to the cost of that discovery, which is massive, you can also potentially steal competitive intelligence from them. And 3 is, by virtue of jamming them up in litigation, you can destroy their reputation in the market, because you can go out to all of their customers and third parties and business contacts and relationships and basically make it clear that, hey, you don't want to do business with this other company over here because, we're suing them for theft of trade secrets. And if a big, multi-billion dollar, corporate concern is suing a smaller rival, let's say on one hand you've got a company that, $2-3 billion company. On the other hand, you got a small company that's doing, $20-30 million this year, but, poised and sort of to ramp up and do 50-100 million, in short order, right? If the big bad wolf multi-billion dollar corporate actor sues them and alleges theft of trade secrets, people are not going to touch the defendant, right? They're not going to do business with the defendant. I've seen it happen 1,000,000 times, right? 1,000,000 is an exaggeration, but I've seen it happen hundreds of times in the course of my career, where somebody gets sued for theft of trade secrets by the bigger corporate actor, the multi-billion or many hundreds of million or whatever company, the big bad wolf. They sue the smaller company, and the smaller company is effectively frozen out of the marketplace. Nobody wants to touch them or do business with them. Not only customer-wise, but financing, capital, whatever it is. Nobody wants to touch them as a result of the frivolous trade secret litigation. So if you're a corporate plaintiff, right? If you think about it from the corporate plaintiff's perspective, the corporate plaintiff has virtually nothing to lose, because, look, courts are hesitant to whack corporate plaintiffs for bad faith trade secret litigation, right? It's a very high standard, okay? The trade secret case has to have been filed in bad faith, right? And that has become, as a result of sort of, case law and various decisions, that has become generally a very high standard to meet. And that's problematic, because there are so many companies that look at this and say, okay, what's our risk here? Well, our risk, we file a lawsuit for theft of trade secrets, we bury the other side in legal fees, we get access to their own confidential information and trade secrets through discovery, we freeze them out of the market and prevent them from taking any market share, and possibly take their market share because people are afraid to engage with them. And our only risk, our only downside here is that we possibly get whacked for the other side's attorney's fees under a bad faith standard. It's a very high bar for the defendant to ever get there. The defendant is unlikely to overcome that bar if they can even afford to litigate the case to a resolution on the merits. So, having laid out sort of what the problem is and how ugly it is and how nefarious it is, we have to ask ourselves, what are the possible solutions for this? Well, obviously, on one hand, it's a complicated balancing act in terms of penalizing market actors for legitimately seeking to protect confidential, proprietary, or trade secret information. We should have, on the front end, a more truncated process in which courts, federal and state, can do a sort of quick look analysis of a trade secret case and then dismiss it without allowing it to progress to the next stage, where it can become incredibly burdensome and incredibly costly. I think there's enough trade secret litigation today, and there's enough of it that's frivolous, that we have to do something with respect to disposing of these cases earlier in the process, because far too many trade secret cases that are objectively absurd are going the distance and costing the defendant, tremendous sums of money in attorney's fees, in addition to all the other externalities we've discussed. We have to do something to create a a truncated procedure for disposing of these trade secret cases on the front end. That's one. Not sure how that's accomplished, but that's something that we need to consider from a policy standpoint. Number two is sort of far more viable as a right now strategy. So more often than not, when these corporate plaintiffs pursue an action for theft of trade secrets, they tend to have big mouths, and they tend to go out into the marketplace and engage in a concerted smear campaign against the defendant, right? So I have seen this happen dozens of times, and I have litigated several of these types of cases in the course of my own practice over the years, right? You see, somebody leaves company A, they don't have a non-compete agreement, they start their own company. Company A freaks out about company B encroaching on its market share. Company A sues for theft of trade secrets because it's the only claim they can bring. They don't have the non-compete claim, so they sue for theft of trade secrets, or they sue for the non-compete if there is one and theft of trade secrets. And then they go out into the market and they basically tell everybody, hey, you better stay away from company B. Company B stole all our stuff. They stole our technology. They stole our proprietary information. They misappropriated trade secrets. They're engaged in illegal competition. What they did was illegal. They might go to jail. I have seen this. I've seen all these things, right? The accusation of conduct that was illegal, the accusation about, they're going to go to jail, they're going to be enjoined, you don't want to get dragged into litigation, right? I have seen that happen in multiple instances. And so, some people say, well, just accusing you or just accusing a departing employee of stealing trade secrets, that's not actionable. And you say, yeah, they stole trade secrets, it's not actionable. The heck it's not. I've had cases where federal judges have said the allegation that the defendant going out into the market and telling other people in the market he stole our trade secrets, he's a thief, that is per se defamation. So it's not just if proven, right? That's not just defamation. It can rise to the level of per se defamation. Well, what's so great about per se defamation? Well, if you practice in this space, you need to understand that per se defamation is where it's at. Because if it's defamation per se, if it's a statement that is of such a nature that it inherently reflects poorly on your reputation, it's inherently harmful, right? It's inherently injurious to your professional standing, to your business, to your livelihood, right? Then it can rise to the level of defamation per se, and saying that people shouldn't do business with you because you stole trade secrets and you're a thief and what you're doing is illegal. That necessarily injures your business reputation. That's defamation per se. What's that mean? Well, it means you get presumed damages, right? In certain jurisdictions, depends where you are, but there are a number of jurisdictions where you are entitled to damages being presumed, which means what? The jury instruction. And so this is where it all comes back to, folks. For young lawyers or for lawyers who have not taken that many cases all the way through litigation to trial, what you ultimately come to learn is that all these cases come down to jury instructions. That's where it's all made or lost. The jury instruction and what the jury instruction says, right? And when you're thinking about a claim or a cause of action or proving your case or defense, whatever it is, if you want to consider, what you really need to do at the end of the day at trial, or what really needs to be established, or what you're really going to get or could get, you have to read the pertinent jury instruction. And the jury instruction is basically going to say, if you find that it is defamation per se, you are to award damages to compensate them, in an amount that you think is, reasonable to compensate them for harm to their reputation. What? Wild card. Could be a huge number, right? And that number obviously is going to depend on, exactly what was said, how egregious the defamation was, the defendant, what their standing was in the community before those allegations were made, what their reputation was, what their track record was, how sympathetic they are, etc. But defamation per se opens the door for presumed damages, and not only presumed damages, but also punitive damages. And then that's a whole nother ballgame where punitive damage is intended to punish that sort of misconduct, and they are only limited by some states that have damages caps on punitive damages. And then if there's no state punitive damages cap, the federal cap, constitutional, state farm 10 times whatever the underlying damages were. So you have a case like this where a jury awards $1 million in presumed damages for reputational harm for defamation per se, and then they can award $10 million in punitive damages to punish that misconduct. Now all of a sudden you're at $11 million. That is by far the strongest weapon for combating these types of frivolous non-compete or trade secret cases, or these cases that involve frivolous allegations about use or misappropriation or unfair use of allegedly confidential and proprietary information. The best strategy for countering this is a defamation per se counterclaim where you open the door to get punitive damages, because those types of claims can often be litigated with far less manpower, resources, discovery, etc., than the trade secret claims on the other side. So, Jonathan Pollard, Fort Lauderdale competition lawyer. If you practice in this area of law, hopefully today's discussion was helpful. Have a good one.